Okay, so I think everybody has to accept. So yeah, Sean, if you don't mind introducing yourself, that would be great, and we'll go from there.
Perfect. Well, good evening. My name is Sean St Clair, and I am a real estate attorney in Scottsdale, Arizona. My practice focuses on real estate and business transaction work. Basically, the way I describe it is I handle pretty much anything that touches real estate besides litigation and disputes for the most part. So, if it involves planning an estate so that, you can properly convey real estate upon passing, I handle it. If it involves, entity structure, if it involves creative financing, wholesale, contracts, novations, etc., I handle them. So I basically, if there's a real estate related contract out there, I have drafted it or can draft it. So that's basically my practice. I'm very active in the real estate investor community. I've started a Facebook group that has well over 1,000 members, a number of attorneys, called Real Estate Investor Legal. If you're so inclined, you can join the group. Basically, the whole purpose is to connect real estate investors with attorneys that are friendly to real estate investors and know the issues that they deal with. One of the things that I regularly have and still do is on a weekly basis requests for attorneys outside of Arizona that basically do what I do. So I've created this group to try to connect other attorneys outside of Arizona, even within Arizona, with real estate investors. And then I've also created a fairly encompassing referral list of attorneys outside of Arizona that work with real estate investors and know the different issues that come up with real estate investing. So as far as my presentation goes, I'm going to share my screen in a minute, and I have a PowerPoint. But I do encourage questions. So if you do have questions as we go, feel free to, I don't know if Zoom has a raise your hand feature, or frankly, just unmute and jump in and ask me any question that you want. I'm happy to answer it. And then at the end as well, I'll have an opportunity for questions. So feel free to jump in and, interrupt me, and I want it to be interactive.
Okay, cool. So see if you can share.
Okay,
now.
let's see here. So I should be able to, at this point, share screen. Oh, host disabled.
Okay.
So there should be, just a setting.
Yeah. Okay, I think you can share now.
Okay. Yep.
Good, excellent.
There, can everyone see my screen okay?
Yes.
Perfect. And you, it says entity structures for real estate investor. I have two screens, so I just want to make sure I'm sharing the right one.
That is correct.
Perfect. Okay, excellent. All right. So basically, this presentation deals with how to structure your entities, how to structure your real estate holdings to do two things. One is to convey assets if, God forbid, something happens to you, who receives your assets and setting that up. And then the second is, how do you plan to protect yourself in the event of a catastrophe or a lawsuit that, where you have liability. So the first thing we need to talk about, let's see here. So our considerations. So the first one is estate planning, right? Who receives your assets should something happen to you, should you pass away? The second is asset protection. That's dealing with the situation involving, say, a lawsuit or other claim against you. The third consideration is anonymity. Do you want people to know who's behind the real estate, right? Who's behind the corporation or the LLC that owns the real estate? So anonymity isn't truly asset protection because asset protection really involves the corporate veil in creating entities, LLCs, corporations to provide protection. Anonymity is more of a deterrent, and we'll talk about that a little later on. And then finally, you have taxes. You know, now I'm not a tax attorney or a CPA, but I know enough to, you know, be dangerous, if you will. And so we'll talk briefly about taxes and the advantages of different structures and, you know, tax designations for entities to basically take advantage of certain, you know, tax codes and laws. So the first consideration is estate planning. Who inherits the asset? The assets, right? Who are your beneficiaries? Who receives your assets? The next consideration is who handles your assets upon death. So who receives your assets could very well be different than the person who actually handles your assets, right? The person that's responsible for distributing the assets and providing them to your beneficiaries. Next is who handles your assets upon disability. Now, a lot of times that's the same person that handles them upon death, but it doesn't have to be, right? Sometimes the person upon death may be somebody outside of the state where you live versus, well, maybe if I'm disabled, I want somebody within, you know, locally to be able to step in, you know, in fairly short order and handle my affairs in the event I become disabled. So it could be a separate person depending on, you know, the elections that you make. And then finally, for estate planning, well, not finally, fourth for estate planning is who will make medical decisions for you. You know, if you're in the hospital, you're in a position where you're unable to make medical decisions on your own behalf, who's going to make those decisions for you? And, you know, that's part of the estate planning process. And then finally, if you have minor children, who are going to be your guardians? Who are you going to designate to care for your kids should you either be disabled or pass away? Who's going to step in and raise your children? So when we talk about an estate plan, we talk about the documents, right? These are the documents you're going to execute to put the plan in place. So the first one is a will. And a will can be a general will. So we refer to that as a last will and testament. The will basically says, okay, I'm going to appoint this person as personal representative, or some states call them executors. This is the person who's going to step in the event that I pass away, and they're going to take control of my assets, and they're going to be responsible for distributing my assets to the individuals that I designate. And then the will is also going to designate the beneficiaries of your assets, who's going to receive those assets. Finally, the will is going to designate guardianship. If you have minor children, who will be the guardians of your children? Now, the one thing about a will here in Arizona, and I'm pretty confident it's in every state, the one thing about a will is it does not avoid probate. So for your personal representative or executor appointed under the will to come and step in and handle the affairs of your estate, they're going to have to go to court, and they're going to have to seek appointment with the state court and be appointed that way, and go through the probate process in order to distribute the assets and to close the estate. The other document that we talk about is a trust. This is basically a document that's created that is similar to the will, except a trust basically appoints trustees. And these are individuals, we call them successor trustees. These are trustees or individuals that step in similar to your personal representative or executor, but they step in if you pass away or become disabled, and they handle your financial affairs or the affairs of any asset that's held in the trust. Now, when we were talking about will, we talked about a general will, which was your last will and testament. But if you notice in my PowerPoint here, I refer to a pour over, and that is a different type of will. That is what we call pour over will, and that is a will that's done in conjunction with a trust, which instead of naming individuals as beneficiaries, a pour over will names the trust as the beneficiary. It pours over into the trust. Now, a pour over will would still appoint an executor or personal representative, but their sole job would be to then take the assets and move them into the trust. Now, depending on the nature of the assets and the value of the assets, if the person who created the trust was not good about moving their money into the trust, then you still may have to do a probate in that case. But the probate would be for the sole purpose of moving the assets from the individual's name into the name of the trust. And that would be the sole role of the personal representative. But a trust avoids probate. You do not have to do a probate with a trust. The next document is a financial power of attorney. A financial power of attorney is a document that exists during your lifetime. And this really kicks into play in the event of a disability. If you all of a sudden don't have the means to think or act on your own behalf, then your agent, who's appointed under the financial power of attorney, can step in and manage your financial affairs for you. Now, the minute you pass away, the financial power of attorney is no more. It does not survive death. It is only good during your lifetime. I've seen the financial power of attorney be used successfully in a number of scenarios. One, I've had on 2 occasions clients who were closing on real estate, and they ended up, being away, traveling internationally, and they ended up getting stuck out of the country. And if you've ever, and I've worked with clients to notarize documents outside of the country, and you have to do, apostilles and all kinds of stuff that you normally don't have to do here. It's a real hassle. And it could take weeks to actually go to the proper embassy and track down the right person and do everything you need to do to notarize a document out of the United States. Well, I've seen it where they are stuck, but they're like, we did that estate plan. And they call up their agent and they're like, hey, grab that power of attorney out of our house, take it down to the title company, show it to them, show them your ID, and sign the papers on our behalf. And it worked. So it can be very useful in that scenario. Another scenario that we don't think about is a husband and wife scenario, where one spouse ends up with Alzheimer's and dementia, and the title company learns about it. If a title company learns about that, they are not closing that transaction until somebody has that spouse's authority to execute the documents. So the 2 means of that type of authority is a financial power of attorney or a conservatorship via the court, the probate court. And a conservatorship is easily going to cost $5 to $10 grand, even though it's the spouse doing it, because it's not a simple process. You need medical experts. You're going to basically have to hire an attorney. But then get this, you hire an attorney. So let's say the husband has Alzheimer's and dementia, and so the wife then is now going to be appointed as conservator because they don't have a financial power of attorney. So the wife goes into court, hires an attorney. That attorney is going to charge the wife anywhere from $3,000 to $5,000. But get this, The court then is going to say, well, we're not going to appoint anybody over your husband until we appoint an attorney to represent his interest in this proceeding. That attorney then comes, represents the husband. Well, guess what? Who pays that attorney? Yeah, the couple, the husband and wife pays that attorney. So now you have two attorneys, each charging between $3,000 to $5,000 to have this conservator appointed so you can close a real estate transaction.
So wait, but if you have that financial power of attorney ahead of time,
You're golden.
then you're fine.
Yeah, if you have a $350 document ahead of time, you're golden.
Well,
Yes.
everybody's still sane.
Right, exactly.
Okay.
Mhm.
And that would be, but is that a third party person if it's husband and wife? I guess I'm confused there about what you just said about the medical.
So the financial power of attorney, generally, if it's a husband and wife, they appoint the opposite spouse to be their agent.
Right. But then if
Yes.
both people, like what you said, then they're out of the country, then is there a third person?
Yeah, so what we've done in that, so one of those scenarios was not a husband and wife, it was just a single person that was trying to sell real estate. And so the person was here. The other one was a couple, but what we did was we were able to work with the title company to prepare and have executed a waiver of agent appointment that the title company signed off on. And then we had them docu-sign it and the title company accepted it
Okay.
with an avowal, if you will. So the
You don't have to
spouses,
have a third person. Like I wouldn't do my husband do me, and then both of us have my son or something.
yes, that's what you would want to do. Yeah.
Okay.
Yep.
Okay. Thank you.
Yeah, you bet. And then your last document is your healthcare directive. And so what a healthcare directive is basically instructions to your, well, number one, it's the appointment of an agent to make medical decisions on your behalf in the event that you can't make them. So it's basically similar to a financial power of attorney, but it's a power of attorney for health and medical reasons. Then second, a healthcare directive is where you make elections like do not resuscitate type of elections that you basically say, okay, in this scenario, I want this treatment, but I don't want it in this scenario, or, those types of things. So you make your elections there, you make your burial elections, you make your organ donation elections, those types of things are what is found in the healthcare directive. All right, when we talk about trusts, we talk about two types of trusts. The first is revocable, and the second is irrevocable. So the first type of trust is revocable, which, when you talk about an estate plan and somebody says, oh, I went and did my trust, my family trust, 95, maybe 99% of the time you're talking about a revocable trust, a trust that can be revised at any point by the individuals that created it. And there's very limited tax protection. There's some tax planning that we can do for larger estates to take advantage of the estate tax exemption. So there's a way we can draft a trust for a married couple to basically double the estate tax exemption. And what I mean by that is presently federal law provides, and Arizona follows the federal law. Federal law provides that unless an estate has assets of 10 million and change, then there is no estate tax. Well, if a married couple, let's say they have 15 million in assets, we can structure the trust in such a way that each we can basically use each spouse's $10 million exemption to create a $20 million exemption. So even if they're, at the 15 million mark, there wouldn't be estate tax, if that makes sense. So it's very limited tax protection, but there is some planning that we can do for that. But it's a flow through vehicle. And what I mean by that is you can't shield assets in a trust. If I create a trust with my wife and I, we put all of our assets in the trust, and I'm off driving around and I end up, causing an accident resulting in serious injury or death, and I'm underinsured, the victim would have the ability to sue me and to sue my trust and seek, the assets found in my trust. And there was nothing I could do about it, because you can't shield assets in the trust. In fact, Arizona has a very specific statute talking about that and basically saying a revocable trust, allows for flow through access. You don't get to shield. Now, an irrevocable trust does provide asset and tax protection. Now, I'm not going to get into the tax protection because that really is beyond my practice area. There are attorneys in the Valley who, and when we're talking about tax protection, what they're trying to do is, take somebody who has $50 million in assets and make it so that there's no estate tax on that 50 million. So they charge 30, 40, 50 grand for an estate plan to do these different irrevocable trusts and charitable trusts and this type of trust and that type of trust and, intentionally defective trusts. I mean, you name it, they're doing it, right? So, that's beyond my scope. And if somebody came to me and said, hey, I want to do this type of planning, I'd say, oh, go see, so-and-so. I have a few referrals that I would send them to. But basically an irrevocable trust is one that's irrevocable. You put your money in there, you designate the, now you can use it for your own health, welfare, and maintenance, but you're not supposed to, convey large assets out of it. And you basically can't change your designations. They're locked in. And so it's not my favorite vehicle for asset protection. Frankly, for irrevocable trusts, I normally will refer those out, like I said, but they are doable, and they do provide asset protection because basically, you create them, they have their own separate EIN number. They're their basic own separate entity. I mean, it operates independently from what we call settlers, the individuals that created it. It acts independently versus a revocable trust is basically the same as the settlers' assets. I mean, they can, use it, give it away, make changes to it. They have full and complete control over those assets. All right, let's talk about the main players. So grantors, they're also referred to as settlers, but they're basically the creators of the trust, the individuals that created the trust. The next is your original or initial trustees. In a revocable trust scenario, that 95% of the time is going to be the grantors, the individuals that create it, but it could be different. In Arizona, I don't do it because in Arizona, there's no point in doing it. But there are land trusts out there and that work in other states for anonymity purposes. In Arizona, it doesn't work. So we don't create land trusts, but in a land trust scenario, your trustees would likely be separate than your grantors. You would generally have a private, trustee that is named, that would be named in, other individuals' land trusts so that there's, this anonymity, no one knows who's behind the trust. Then you have your successor trustees. So these are the individuals that come in and take over after you pass, or you become disabled. They step in and take over. Basically, your successor trustees are normally the same individuals that you appoint as executor or personal representatives of the pour over will, but they don't have to be, but 95% of the time that they're going to be. Then you have your beneficiaries. So these are the individuals that are going to receive assets. These are the ones that receive the trust assets. They benefit from the trust. Now, your initial beneficiaries on a revocable trust are always going to be the grantors, the individuals that created the trust. They're the initial beneficiaries, which is why, basically there is no separation. The grantors and the trust are basically one and the same. They're free to use the funds as they see fit. And then finally, you have guardians, and that's optional. But, if you have minor children, you can designate in the trust and in the will who you want to be guardians. Now, I say that to, as far as guardians, it is a designation. The court has discretion. The court does not have to honor, your guardianship designations that you put in there. Now, 90% of the time the court's going to, but, if you appoint somebody and then, one of your family members comes out of the woodwork and says, wait a minute, they've appointed this person, but let me tell you about this person. They pull out a criminal record. The court may not be appointing them despite the fact that you've named them in your, trust or your will. So the court ultimately is the final decision maker on that, but they generally try to honor, assuming, something weird like that, as far as like criminal record or something like that coming out of the woodwork, they generally are going to honor those designations. What are the advantages of the trust? Well, we already talked about this. It avoids probate. So, it's private, it's not public, and you can go and distribute the assets and manage the affairs of the trust without filing a court proceeding and going through, the probate court. You have unlimited succession planning. So you can say, okay, I want, A and B to inherit my assets. If A dies, then I want A's children to inherit my assets. And if A's children die, then I want, B to inherit their share, and I want B's children. Or frankly, if there's a combination of succession planning that you can think of, we can put it in a trust. I mean, it's basically unlimited, and you can be as creative on it as you can be. The other is it's best for minors. So without a trust, if you have minor children, basically what happens is the assets go into probate, and then the court requires that a conservator, which we've already talked about the expense involved, right? A conservator be appointed for the minor child, and then the funds be handed to the conservator, but in a restricted bank account. So now every time that the minor wants to access the funds, they want a new laptop for school, they want to pay their tuition, whatever the case may be, you have to go into court, file a petition, ask the court's permission. The court then issues an order. You take that to the bank, you get the money, you pay the expense, right? You have to do that over and over and over again until they reach 18. And then guess what? When they reach 18, time to write the check for the full amount. Here you go, unfettered discretion to use the funds however you see fit. I don't know about you. I have an 18-year-old. There is no way I would want him to have any, significant assets, because it would be gone in short order, right? I mean, but most 18-year-olds are that way. I mean, that's just how they are. And so for a trust, we can say, okay, we're going to appoint somebody to take control, a trusted individual to take control of those assets. They have the discretion. They don't have to get court approval. And here are some of the things, and you can even designate in the trust some of the things you want them to use the funds for. Even buying a house, buying a car, I've had clients say, a used modest vehicle, right? So, they put things in there that they want, and their wishes, and then that trustee is free to use it and take care of that child and provide for that child until whatever age they designate. So, a common planning technique is we'll give them either half or 1/3 when they turn 25, and then we'll give them half or 2/3 when they turn or the remaining amount when they turn 30, or 2/3, and then when they turn 35 they receive the remaining 1/3. So there's a number of planning techniques that can go in dealing with minors and children that you just can't do anywhere else. You just can't do it with a will. You can't do it with, and I haven't really talked about, but a beneficiary deed. You can't do it with any of that. You can only really do it with a trust when you're talking about minors.
We did that with our kids.
Yeah, right. It makes sense, right? I mean, you feel better about it when you have something like that in place and a trust.
They're almost 30 and I still wouldn't give it all to them. We have it up.
Yeah, right.
We
exactly.
literally have it up to 40. We did like 25% on death, another amount at 30, another 35, and then they could have it all by 40.
Right. Yeah, makes sense. I mean, you just, I've had clients who came to me years ago and they had young children and we did the planning and now the children are, young adults and they're like, oh, these are the most responsible kids that I know of. That's great. You did well. So they change their estate plan and they get it outright because they trust the kids at that point. That's great. Not for me, but it was for them. So you just never know. And each child, each person, individual is, more responsible than others, but.
Absolutely.
Then you have your spendthrift provision, right? So this is an interesting provision. And you may have heard this term before, but basically what it says is, hey, look, if I have a beneficiary out there that has somehow managed to find themselves in, financial hot water, they have, creditors breathing down their necks, et cetera. We just keep the money in the trust. We'll just keep the money in the trust. And it's not going to be distributed to them. And we're going to hold it. And then the creditor does not have the right to access the trust. Now, there's certain provisions that we have to put in there as far as making distributions, in that case, discretionary and those types of things. But nevertheless, it avoids creditors from, mingling, and intermeddling in the affairs of the trust. We already talked about the estate tax protection that we can do with doubling the estate tax exemption for married couples. Once again, there's asset and tax planning that can be done with irrevocable trusts, and it can eliminate unsecured creditors with notice. So one area, and you'll appreciate this from a real estate standpoint, where this came in really handy. We had a client who passed away and he had solar panels on his roof under a long-term lease. So we sent notices to the solar panel company, the, I guess, lessor would be the proper term. We sent them to the lessor, said you have 4 months to notify us of your claim and that you want to be paid from the estate. And if you failed to do it, you're out. And guess what? They failed to do it. So we then, we had certified mailing and they received it, and they signed for it, and we knew they received it, and they didn't do anything in the 4 months. So we went to them and said, we're selling this thing, get those panels off of our roof. And they're like, what? Yeah, get them off our roof. This lease is gone. It's terminated. You didn't make your claim in 4 months. And they came to us and said, well, shoot, this is scrap metal at this point. These have no value. And we're like, well, sorry, but, take them down and, don't damage our roof in the process. And they said, well, tell you what, will you buy them? And I'm telling you, we bought them for like pennies on the dollar. I mean, it was like literally nothing. Instead of them taking them off and, spending their resources doing that for scrap metal, I mean, it was like a few $1,000, to buy these panels outright. And so it really came in handy, because otherwise that lease, if it accelerated, which it did upon death, I mean, it was like a $40,000 check, that would have to be written. And, so hopefully everyone on this call knows, like, solar panels are a disaster when leased. So be careful, when you're negotiating with a buyer, not a buyer, a seller, and they have solar panels, you better get a copy of that lease and figure out, what's going on and whatnot, because they really are a hassle and difficult to sell properties with them on there. But we were able to use this to, eliminate that claim. So, that's just one example where it benefits, a real estate transaction. But there's other, credit cards and things like that we can do to eliminate claims against the estate. What's the disadvantages of the trust? Well, it's the most costly estate planning option. I mean, there's no getting around that. It's expensive to set up. It also can be cumbersome to transfer and maintain assets in the trust. I mean, once you create the trust, now our office, as part of our estate planning process, will prepare all the deeds necessary to transfer any real estate holdings into the name of the trust. And we'll get those, assuming it's in Arizona, we'll get those deeds recorded and take care of that. We can also, if it's outside, we work on referring the matter to an attorney outside or a document preparer outside of Arizona who can do it for real estate outside. But you still have your mutual funds and your bank accounts and your retirement, and there's a whole process to do that, and life insurance and things like that still has to be transferred over and titled into the name of the trust. And then every new liquid asset like that, you need to put in your safe deposit box that needs to be in the name of the trust, those types of things. And so it can be somewhat cumbersome to maintain and deal with. And finally, it can subject real property to claims of creditors. And what I mean by that is right of survivorship transfers are done free and clear of claims of creditors. Same with a transfer via a beneficiary deed. Versus if the real estate is in the trust, you have to pay creditors before you can distribute. Creditors who make their proper claim, you have to pay them before you can distribute assets. And so all of a sudden now you have a piece of real estate that you may have to sell, use part of the proceeds to pay a creditor, versus if it were right of survivorship or a beneficiary deed, it could be conveyed directly without having to pay that creditor. Now the creditor may have a claim against other assets of the estate, but likely wouldn't have a claim against the real estate. And then finally, no anonymity. In Arizona, we have a statute, and there might be one or two other states nationwide that have a similar statute, but basically the statute states that anytime you transfer real estate into or out of a trust, you have to list and disclose on the deed the names and addresses of all beneficiaries, current beneficiaries of that trust. So there is no anonymity in Arizona when trusts own real estate. You're having to disclose the names of the beneficiaries by law. And you don't have a valid deed to or from a trust if you don't make that disclosure. And so, every title company in Arizona is going to make you make that disclosure because they know that that's necessary for a valid deed. I'm going to move on to the asset protection components. Does anyone have any questions regarding the estate planning?
I had a question at the beginning.
Sure.
You were talking about pour over wills, and you said if the person is not diligent about transferring their money in there. So I kind of wanted you to elaborate a little bit more on what we should be doing with that.
Yeah, and that really gets to the bullet point number 2 that's up on the screen, which is it can be cumbersome to transfer and maintain assets in the trust. Basically, to avoid probate, you have to title your assets in the name of the trust. So your bank account, your savings account, your mutual funds, you'll work with your financial advisor on any type of retirement and life insurance because there's certain procedures that have to be involved in that. Your real estate needs to be transferred into the trust. Basically any asset of any value needs to be held in the name of the trust.
I thought that was the advantage of doing a pour over.
Yeah, well, the pour over is your last resort. So the pour over simply moves it into the trust, but then you have to do probate if the trust doesn't hold the asset. So if the trust holds the asset, the pour over will doesn't even apply because the trust owns it. You have to think of the trust as being the separate, being, if you will, that can hold assets, that can maintain assets separate from the individuals. And so if you put your bank account into the name of your trust, so your trust is actually the account holder. Your savings account, the trust is actually the account holder. Your safe deposit box, the trust actually owns that safe deposit box or the right to that safe deposit box and the assets in it. Vehicles that are, valuable. You have a Tesla free and clear. You probably should title that vehicle in the name of the trust, right? Those types of things. Any asset of substantial value should be in the name of the trust. If you fail to put an asset of substantial value in the name of the trust, the only way to move that asset into the trust after you pass is to use the pour over will and open a probate and have the court appoint someone to be personal representative of your estate. And then they have the authority granted to them by the court via the pour over will to convey the asset. But you don't want to do that. The whole purpose of the trust is to avoid probate, which is why you have to transfer and maintain assets in the trust, not, individually. That makes sense.
Sure, thank you.
Yeah. All right. Let's move on to asset protection. So first and foremost is insurance, 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 insurance. So, we can talk all day long about, asset planning, asset protection, things like that. Your best protection is good insurance. Don't be underinsured. If you have real estate holdings, you should have, good basic coverage and then an umbrella. Umbrellas are cheap. Most personal injury claims are not going to exceed insurance and the umbrella. See, on personal injury claims, that's, one of the main things that we're planning for, right? Is, somebody coming onto the property and falling into the pool and drowning, being electrocuted. You're out driving around and you cause an accident, that results in serious injury or death. Those types of things. A 2 million, 3 million, 5 million umbrella policy is going to be more insurance than 95% of Americans. And remember, attorneys are taking these cases on contingency. So they're receiving, there is no magic number, but let's just say hypothetically, because it's all negotiated. But let's just say they're taking 30%, a contingency fee of 30%. Well, think about if you have a $500,000 base coverage plus a $5 million umbrella, and the attorney's like, and maybe the claim's 8 million, but the attorney's like, man, I could, get $5,500,000 for my client right away, and then I get 30% of that. I mean, that's a huge number, right? Or I can file, and so I can make that demand. Now, if the insurance company says, sure, we'll pay you policy limits, the insurance company is obligated and will find themselves in the worst scenario they could ever find themselves in if they were to pay policy limits and not obtain a release of liability for their insured. They're never going to do that. That's bad faith. And you talk about, 5 million going to 30 million really quick. It would if they did something like that. So the insurance company will only pay the 5 million plus the $500,000 if the victim or the plaintiff and their attorney execute a release of liability and sign off on no further claims. So basically the victim and the attorney have a choice. Do I take 5,500,000 today, or do I file the lawsuit, let it make its way through the court system, and 2 years later, maybe get a judgment greater than that amount. And then I can collect on that. Oh, and by the way, maybe I can collect on these other assets. Now, with that said, is it a possibility? Yes. I mean, I don't want to say no. I mean, if you have sizable assets, and if the attorney is doing what they should be doing ethically, they're going to look at that and say, you know, we need to pursue those assets. You know, this is what's going to make my client whole. So I need to do that. And so, you know, that is a possibility. But bottom line is, insurance is, you know, first and foremost, the best protection and provides, you know, the greatest protection. The next is what we're going to talk about here, which is using the corporate veil. So using entities to shield personal and business assets from liability. So the first type of entity is a corporation. Corporations can be for-profit or not-for-profit. Not-for-profit's really not designed for asset protection. That's, you know, your charity type, you know, entity. That's an entity that you form where you want to receive donations. Now in Arizona, you can go and form a not-for-profit, a nonprofit corporation, but you still have to take steps to, if you want donations to be tax deductible, for example, you have to go and file separate forms with the IRS and go through that process. And I'm not going to get into that because it's really not for asset protection. But for-profit corporations are the ones that you're going to use, you know, for a business and to try to shield assets. Now, at least here in Arizona, for corporations, if you form a corporation, you must file an annual report. So every year you have to file it. And if you don't file it, you're subject to administrative dissolution by the Arizona Corporation Commission. So it's an issue. It's something that you have to be aware of. And it used to be that the Arizona Corporation Commission would send out a letter, you know, annually and say, hey, in 3 months, you have to file your annual report. Here's the annual report, fill it out, whatever. They don't do that anymore, right? It was expensive. So they basically just tell you when you form, here's the date that your annual report's due, and you need to calendar it. You don't get notices. The only time you might get a notice is when they've inactivated your corporation, which is a bad situation. Most of the time you can just reactivate it, but if you wait too long, then it's dissolved and you may lose your corporate, you know, protection there. Main players. So corporations, you have shareholders, also known as the owners. And then you could have members. Now that's optional for nonprofits. And the only reason I throw that in here is because HOAs, homeowners associations, are nonprofit corporations and they have members. And so, you know, that's an example of a nonprofit involved with real estate where you know, have members, but they're optional and you only find them in nonprofit corporations. You don't find them in for-profit corporations. For-profit corporations have shareholders who own stock. You know, it used to be, right, you would own stock certificates, not anymore. You just own shares as shown on the books of the corporation. Then you have directors. So these are your overseers. You know, we call them a board of directors. They're the ones that basically have that 30,000 foot view and meet on a regular basis to discuss the affairs of the corporation and basically give directions on, you know, what the corporation needs to do, how it should be operating, that type of thing. And then you have your officers. Those are the people that run the corporation day in and day out. So when you talk about your officers, you're talking about your chief executive officer, your chief operating officer, your president, your secretary, your treasurer. A lot of times officers are the same as directors, but not always. They don't have to be. But those are your basically three levels. You have your shareholders, your owners, your directors, and then below those are your officers. Taxation. So you have, and there are others, there's like B corporations and things like that. I'm not gonna get into that today. But you have C corporations. So these are your big, you know, Fortune 500 companies, you know, your large corporations that are going to be taxed as a going concern. And then when they do distributions and wage, W-2 wages and things like that, there's taxes there as well. So it's C Corps end up with double taxation. Now there are tax benefits sometimes for C Corps, but they're double taxation entities. Then you have your S Corps. Now, S Corps are your what we call closely held corporations. So these are your small corporations. And there's tax advantages for S Corps because you don't have the double taxation, and your distributions from S Corps are not taxed on the corporation side. So you do save, the more distributions you pay versus W-2 wages, the more money you save in taxes, if you will. And then of course your nonprofit, which is not taxed. So your corporations have a corporate veil of protection. Your corporations are separate from your shareholders, your directors, and your officers. It's like it's its own separate human, or not human being, right? Its own separate thing, living and breathing thing that owns assets, that manages its own affairs, and it needs to be kept separate from the shareholders and the officers and the directors. It should have its separate tax identification number, its separate bank account, should have bylaws on how to operate. It's separate, and when contracts are signed and entered into, it should be entered into in the name of the corporation, and when they're signed, it should be the corporation name at the top, followed by and the name of the person signing it, comma, CEO. So you can show I'm not signing this as Sean St Clair, I'm signing this as the CEO of the corporation, right? I'm signing on behalf of the corporation. But that's what gives you that corporate veil of protection. And so what I mean by that corporate veil of protection is, let's say hypothetically, I have a corporation that I own stock in, I'm a shareholder. Let's just say my law firm, for example. And one weekend I'm driving around, I'm going to the market, nothing related to my work as an attorney, nothing related to my law firm. I'm driving to the market and I blow a stop sign and I hit somebody walking in the crosswalk and they're killed, right? Tragic situation. And it's, let's just say, a $10 million claim at this point. A judgment can be entered against me personally for that, but a judgment cannot be entered against my law firm because it's a separate going concern. I was not driving for the business. It had nothing to do with the business. So there is no judgment against that company. They can't then go to my law firm and be like, oh, you owe us $10 million. Now, if I'm an employee of the law firm, then they might be able to garnish my wages, for example. But it's only 25% of my wages. It's not my full paycheck. And they could try to, maybe go after my stock or things like that. But the corporation determines, how money flows, where money goes, that type of thing. But there is no judgment against the corporation, against, for example, my law firm. My law firm, they can't go after the law firm's assets. If the law firm owns a building, they can't go after the building. If they, have money in the bank, they can't go after money in the bank. They can't do any of that. They're limited to a judgment against me and me only. Likewise, if my law firm enters into a contract, say our landlord, and we didn't personally guarantee our lease, and the law firm decides to fold up and it has 10 years left on its lease, and all of a sudden our landlord has a $100,000 claim. Well, if the lease was properly entered into between the landlord and the law firm, and the law firm is the tenant, the only claim that they have is against the law firm. They can't go after my personal assets. They can't go after my, vehicles, my real estate. They can't go after the money that I have in the bank. They can't go after any of that. They can only go after the law firm and whatever assets the law firm has. That's the significance of the corporate veil of protection. It creates this separation between an entity and the individuals that own the entity or work within the entity. LLCs. Now, I want to draw your attention to the difference between LLCs and corporations. LLCs are not the same as corporations, even though they are entities and they do have the corporate veil of protection. One key thing for LLCs and why I prefer LLCs over corporations is you do not have to file an annual report. So there's no ongoing, at least here in Arizona, there's no ongoing obligation to, because every time you file an annual report, what do you file with it? A fee, right? You file a fee because the government's not going to take any document from you without a fee. And so since there's no annual report for LLCs, there's no annual fee that goes with it either, right? So there's no obligation. An LLC, if you properly designate it, it can last in perpetuity. There's nothing you have to do from a governmental perspective, at least here in Arizona, for that LLC to continue to be a going concern. Your main players, so your members, not shareholders, members. These are the ones, individuals that own it. And they don't own stock. They don't own shares. They own an interest, a percentage interest, up to a maximum of 100%. And it always has to be 100%. It can't be, you can't have somebody owning 90% of an LLC and nobody owning the other 10. There's always 100% ownership of an LLC made up of members. So, you know, for example, my law firm, I have 3 partners. And so our law firm actually is an LLC. I used it as an example as a corporation, but our law firm is an LLC. We have 3 members or equity partners. So I own 33 1/3. Andy Fowler owns 33 1/3, and our other partner, Brian Locker, owns 33 1/3% of the company. We don't own shares. We don't own stock. We own percentage interest in the company. And then finally, you have managers. This is optional. So you can form an LLC as a member managed LLC where the members manage the LLC and they're the ones that sign on behalf of the LLC and they're the ones that run the LLC and they're the ones that do the day in and day out work for the LLC. Or you can have managers, which are separate than members. So the members own the company, they own the percentage interest, but the managers run it. So for example, our LLC or our law firm, which is an LLC, we have 3 members, 3 owners, but myself and Andy Fowler are the managers. So it's a manager managed LLC. We run the day in and day out affairs of the law firm. Our third partner, he just owns part of the company, but he's not responsible for the day in and day out, you know, management of the company and doesn't have the authority to manage the company or the law firm. But when you file, you have to designate, do I want it to be member managed or do I want it to be manager managed? And it really depends on how you structure it and what you want to accomplish, you know, in determining whether it be manager managed or member managed. So let's talk about taxation. You have sole proprietorship. So this is an LLC that's owned by an individual or a married couple, nobody else. And then it can be taxed as a sole proprietorship. And it would be, in that case, a disregarded entity, which would not have to file a tax return separate from its owners. Then you have partnership taxation. In this scenario, you have partners. So for example, in our law firm scenario, you know, we could elect to be taxed as a partnership, and we have been in the past, depending on our structure. And the significance of partnership taxation is you can have unequal or uneven distributions. So in the partnership scenario, let's say my 3 partners and I decide we're going to be taxed as a partnership. Well, we can have a whole formula or mechanism as far as how we're paid, you know, so Andy and I could be paid more and be given greater distribution. When I say paid, I'm talking about distributions or not W-2 wages, but distributions. We can be distributed a greater portion of the company based upon the fact that we manage it, for example. But partnership taxation doesn't have the same tax benefits as, say, an S corp. So for S corp, though, allows for distributions to be made without certain taxes being levied upon that. So in a partnership, you can distribute, but at the end of the year, you're going to have to pay the full brunt of the taxes for those distributions. Versus an S corp, you can make distributions and you don't pay the full brunt of the taxes. However, in an S corp, you have to have equal distributions. So there's no uneven distribution. So in my law firm, we are taxed as an S corp. So our profit distributions have to be the same across the board. I can't receive a greater profit distribution than any of my partners. It has to be the same. And then finally, you have your, oh, one last point. I knew there was a point. I was trying to think of it on S corps before I moved on. On S corps, the other thing is you can't just go into an or have an S corp and say, okay, every penny that comes in the door, we're going to distribute out as a profit distribution. You can't do that. So an S corp requires that before you distribute profit, you have to pay reasonable wages to the owner. So for example, in our law firm scenario, we're taxed as an S corp. However, our law firm has to pay myself and my two partners a W-2 wage that is reasonable to be paid to an attorney with our same, office location, skill, number of years of practice, etc. Now, it doesn't have to be on the high end of that scale, but it has to be something that's, reasonable. And so you have to pay some amount of W-2 wages before you can pay profit distribution. So sometimes an S corp doesn't make sense if you're not really bringing in, a significant amount of money, because it's like, well, how are you going to pay wages and profit distribution? So you have to kind of get to a certain level of income before the S corp even makes sense, because you have to pay those wages off the top and then profit distributions. But once you get to that level, it is a pretty good tax vehicle. Obviously, once again, I have identified the fact that I'm not a tax attorney or a CPA. So, talk to your CPA about, how they, if you do decide to form an LLC, how they want it taxed and structured. Then you have a C corp. This would be unusual for real estate holdings. Maybe some of your large, real estate, nationwide real estate investors that are, these huge conglomerates, holding all these different, properties and commercial, landlords and things like that, that just have holdings nationwide with hundreds and hundreds of employees. They may choose to be taxed as a C corp, but it's fairly unusual for just, general real estate investing. And then of course, nonprofit. You can have nonprofit taxation on an LLC. However, in my view, and my experience, the IRS doesn't know what to do with LLC. So it's a little harder to have that, 501c3 designation for an LLC. And it's better just to form a corporation if that's what you're going to do. As I discussed, the LLCs do have a corporate veil of protection. The same as corporations. There's no difference. There's no greater protection via a corporation than an LLC. My preferred vehicle or method of structuring, of entity structuring for real estate investors is the LLC. It's less maintenance. I like operating agreements over bylaws. There's a lot more you can do with operating agreements than bylaws, in my view. And so I like LLCs. I think they're cleaner. They're easier to maintain. They're cheaper. They're more cost effective. All right, so I'm going to just show you a real simple thing, and this is for more of like a long-term hold scenario. But this is a real simple structure where you combine an estate plan with some basic asset planning. So you basically have your family trust that owns the LLCs. So it's the member. And then you have your LLCs below, right? So you have your rental LLC 1. So that rental LLC could own 1 property. It could own 2 or 3 properties, depending on your risk tolerance. And, you know, the practical nature of everything, because, you know, at the end of the day, to receive the corporate veil, the LLC has to have its own tax ID number and has to maintain its own bank account. You can't commingle funds. So you think about it, you get up to, you know, let's say 15 real estate holdings. Well, that's 15 bank accounts. That's 15 tax ID numbers. It may be 15 tax returns, depending on, you know, whether it's a disregarded entity or not. So there's becomes this practical side of like, how much protection do I need versus the practical nature of, you know, operating and you know, managing your real estate holdings. So I have clients who are like, nope, I am putting every piece of real estate that I own in a separate LLC, you know, 1 piece of property per LLC. I have other clients who are like, yeah, I'm going to look at it, a combination of equity and properties, but generally I'm, you know, maybe going to put 3 properties into an LLC, as long as, you know, the equity there isn't, you know, astronomical. And then, you know, once I have my 3 properties in that LLC, I'll form a new one and, you know, work to build up 3 in there and kind of take that approach. But in any event, if we look at this structure, you will see you have your family trust that owns it. And then I like, so that it's, you know, when you sign closing documents and, you know, write checks and sign leases and things like that, you're not having to sign, you know, rental LLC 1 by, you know, ABC Family Trust by so-and-so trustee of the trust. And you got all these layers down just to sign a document. Instead, what you can do is say rental LLC 1 by, you know, so-and-so comma manager, as simple as that, right? And that's it. You don't have to have all these different layers, and you don't have to identify the trust in your lease, you know, those types of things. But that's a real basic structure. So it's all these LLCs would be manager managed, with the member being the trust and the manager being the individuals that formed the trust or created the trust. All right, let's talk about anonymity. So anonymity is not asset protection. Asset protection is your corporate veil. That's what asset protection is. It doesn't matter whether you're anonymous or not. The law provides that as long as you follow and maintain corporate formalities, you don't commingle funds, and you operate the entity separate from the individual, that you can't pierce that corporate veil. And you create that protection, and that's the law. So you really technically don't need anonymity. However, I have clients who think and believe that anonymity is a deterrent. If somebody doesn't know who's behind it, they're less likely to pursue it. If they know that somebody wealthy is behind it or can track down their and figure out their assets, they're more likely to pursue it. There may be some truth to that, but anonymity is nothing more than a deterrent.
Hey, Sean, can I ask you a question?
Yeah, sure.
So when you said that your LLCs should be a part of your family trust, what if they are self-directed IRA LLCs?
Yeah, in that case, you can't really do that because the actual owner of it is going to be like a
The
trust
retirement
company.
account?
And yeah, so you can't really do it that way. What I would do is if you have the ability to do a beneficiary designation under that account, I would do if you're married, do your spouse first, and then your alternate beneficiary designation would be your trust.
Okay, we did alternate spouse, and then we did children.
You can do it
Yeah.
that way if your financial planner likes it and thinks it's good that way. You know, the only thing is, and like you said before, is what that does is it does an end around the provisions in the trust, which prohibit assets being distributed until they turn 40, right?
Okay,
Because those assets are going to be distributed immediately because they're outright beneficiaries, and it's not going to the trust. And so it will never hit the trust, and the trust will never control those funds.
okay, so
But-
with the custodian, then we should put alternate spouse and then the trust.
Yeah, that is, if you want to talk to your financial planner, but if you want the trust to control those assets till your children are 40, then the trust needs to be the backup beneficiary.
Okay, thank you.
All right. So there's two ways that, there may be other ways, but these are the two ways that our office, creates anonymity. First is to create not a land trust, but what I call a real estate trust or a holding trust with an anonymous name that is the member of an Arizona LLC. So for example, you would form the Sun Devil Trust. Because we talk about, the Sean St Clair Family Trust. Most people like to name their trust in their name. You don't have to. You can name a trust whatever you want to call it. And so what you do is you create a real estate trust, the Sun Devil Trust, for example, that then is a member of an Arizona LLC. And then my office, for example, forms the LLC. I sign the paperwork as counsel or organizer for the LLC. My office address is listed for everything. I'm the stat agent, and nobody knows anything other than the fact that attorney Sean St Clair created this entity with this Arizona LLC with this anonymous trust as the member, but they don't know who the anonymous trust is. And while when a trust takes title to property in Arizona, you have to disclose the names of the beneficiary. In this scenario, the trust isn't taking title. The Arizona LLC would take title. The trust is just the member of the Arizona LLC. So you don't have to disclose the beneficiaries when you convey the property to the Arizona LLC or out of the Arizona LLC. The second way is to form a Delaware or Wyoming LLC, which will then be a member of an Arizona LLC. Delaware in particular, we don't really form Wyoming, but I know other practitioners do, form in Wyoming. We form Delaware. In Delaware, you don't have to even identify the members, managers, or anyone else involved in the LLC. You simply prepare a one-page document that I, as the attorney, sign saying, we are creating a member managed or manager managed LLC in Delaware. It has an operating agreement, and the name is, and you give the name, you sign, you date, you fill out, submit that form. That is the only document of record in the state of Delaware for that LLC. And then Delaware approves the LLC, sends out their paperwork. Now, you have to have an operating agreement, because otherwise, how do you know who owns it, right? How do you know, who manages it, the ownership percentages, those types of things? You have to have an operating agreement. But nevertheless, that operating agreement is, not public record. It's kept by my office, and then it's kept by whoever, the manager or members of the LLC are. And so the only way to obtain that would be, those records would be to file a lawsuit. And if you wanted to get them from my office, you're not getting them by way of a subpoena, because I'll refuse for a subpoena. I don't have a duty to disclose pursuant to a subpoena. Now, if you go and get a court order, and that court order says Sean St Clair or Fowler St Clair disclosed that operating agreement, I'm going to disclose it to the court. I have to. But absent that court order, I don't have to disclose that. Now, in the lawsuit proceeding, could there be, discovery that happens from whoever, is named in the lawsuit? And if they happen to be a member or have an interest in the LLC, could they potentially get the operating agreement that way? Yeah, but it's going to require court involvement. And it just is not gonna, you can't obtain that information absent filing a lawsuit. So you have to be prepared to go that direction, go all the way, file that lawsuit, serve that lawsuit, get the court involved to get that document, and it's only that document that's going to disclose who owns the company. Yes, Liz.
Sean, I have a question because a lot of us on this belong to the same organization where we're directed towards Nevada LLCs. So is that a bad thing? Is it something we should look at changing? I mean, I know Delaware and Wyoming, I've heard that now, but in the past it was the Nevada.
Yeah, Nevada still has information on file. They just don't publicly disclose it. Nevada's fine. I mean, you could do Nevada.
Can I add
but,
something on that?
Yeah.
Okay, so Liz, I have mine in Wyoming. I used to have them in Nevada, but it's Wyoming is the same that Sean was talking about as in Delaware. Whoever creates the LLC for you, their name is the only name on there. And Wyoming is a lot cheaper than Nevada. I think I only pay $50 a year versus $350 or something like that. And on top of that, Sean, maybe you could address this. I believe that Wyoming has charging order protection.
I'm not aware sure of that. I don't know.
Yeah. So,
but in switching our companies or switching that, can that be done, or is that a new entity you're starting or something, or?
you can switch it.
I'm doing mine tomorrow. I'm switching tomorrow.
I switched from Nevada to Wyoming, kept the same EIN number, and you make up the cost in 1 year.
Okay.
And I also had a question. I have like
Sure.
one domestic with Nevada, and then I have 2 foreign. One is in my home state. Under the same name. So should I be changing those names? Or the LLCs?
Repeat that. I'm sorry.
Okay, I have one domestic in Nevada.
Okay.
I have one in Arkansas, and I have another LLC in Florida under the same names. So should I be changing those names?
I would change the names. Because to me, if you run them with the same name. So for example, you could form, let's say it wasn't taken, you could form ABC LLC in Arizona. Well, if somebody comes to Arizona to form ABC LLC, Arizona won't allow them. But I could then go to Nevada and form ABC LLC in Nevada, and Nevada is not going to check Arizona. So you have an ABC LLC that's a Nevada LLC and an ABC LLC that's in Arizona. I don't know. The reason why I would switch the names is because you want to basically show that these entities are all separate, right? Because part of creating that corporate veil is structuring. And when the names are the same, the presumption is you're treating them the same. They're the same. And now you run the risk of potentially being able to pierce the veil based upon not being able to establish that they're completely separate operating entities, standalone. But I don't know that it's necessary. Honestly, I've not heard of somebody structuring it that way with all the same. Normally they have unique names and identifiers.
Okay, so we were thinking we needed a LLC for each of those states, but actually we really don't. We can just have one and do business in the various states unless we, like you said, mixing up properties and doing things like that, right?
Right, yeah.
Okay. Thank you for the clarification.
So I'm going to show you this is a more complicated structure.
And one thing, Sean, not to cut you off, but I don't know how much you have, but we got to wrap up around in that 8 o'clock hour. So I just want to make sure you have a timeline for that.
I have 2 more slides.
Okay, no, that's good. I just want to let you know.
Yeah, you bet.
It starts turning into pumpkins,
I'm sorry, I didn't realize I thought I was about the 45-minute mark, and it looks like I'm almost at the hour-and-a-half mark.
Oh, no, you're good. This is good. I mean, we're
Okay,
all learning
okay,
very
good.
much.
So I have 2 more slides, and these are just really, kind of, hey, here's some unique things that we can do, to structure entities and create, protection. So the first one is here that I'm showing you is at the top is the family trust, right? So everything flows from the bottom up and it results in the family trust owning it all. But because you have this anonymous real estate trust in between, nobody knows that the family trust is up here, which is the ultimate trust that's going to, plan your estate, right? It's going to determine where everything goes. And so the beneficiary actually of the anonymous trust would be the family trust, and everything would end up going to that family trust and avoiding probate in the process. And then the anonymous trust would own the rental LLC or LLCs in Arizona, which would be, in this case, an Arizona LLC. And the reason why I'm flowing it this way is because you should not talk to your CPA, but the CPA that I utilize and works with a lot of my clients, and I really trust, I told him over and over, like, man, you should have just gone to law school because you think like an attorney. He basically, his position is rental income should never flow through an S corp. You want to keep that, taxed separately and differently than, S corp, because S corp is really more like professional income and things like that. And so, we have it going through the anonymous real estate trust, but outside of the other entity over here, which is kind of your S corp holding corporation, right? Or your S corp LLC, I shouldn't say corporation, your S corp LLC. And the owner of the S corp LLC is your anonymous trust. So when somebody looks and says, oh, Services LLC, all they're going to see is Sun Devil Trust is the owner, for example, right? That's all they'll see. They won't see anything else. They don't know who Sun Devil Trust is. They don't know who the family trust is. They don't know any of that. And then below the Services LLC would be, your Fix and Flip LLC, your Wholesale LLC, your Construction LLC, your Marketing LLC, whatever, you name it, right? It's going to be below. And so your holding company is Services LLC, and then it owns all of these down below, which when you are in different trades or providing, different services like, Fix and Flip, you don't want your wholesale entity owning your Fix and Flips. I mean, you get sideways with a seller or a buyer on a wholesale, you don't want to expose your Fix and Flip assets to, that type of claim or lawsuit. So same with construction, you get sideways with a subcontractor or an owner or whatever the case may be. You want to keep everything, separate for the different services and things that, practices that you engage in. So that's one. The other one would be the, utilizing a Delaware LLC. And in this case, you would have your family trust, your family trust up here that owns the Services LLC and the Rental Holdings LLC, both of which are Delaware LLCs. And so the Rental Holdings LLC would then own, say, an Arizona LLC that owns Arizona real estate. But when you look at the Corporation Commission, the only thing you're going to see is Rental LLC, which is owned by Rental Holdings LLC. And then when you go to Delaware, you don't see anything. You don't know anything else. But your operating agreement says that the individuals are the managers, so that if they have to sign anything, they can sign, in their individual capacity, and you don't have to have this long signature block. But ultimately, the family trust owns the membership interest, which once again is provided by the operating agreement and completely, not of record with Delaware. And the family trust ultimately owns it so that your estate plan wishes are carried forth, if you will. And then finally, you have your Services LLC over here, which is also a Delaware entity. And it then owns all of these lower level LLCs, so that when you look at, say, construction LLC, the only thing you see is services LLC, a Delaware corporation, which when you go to look at Delaware, you see nothing but a form that says, I, Sean St. Clair, attorney, am forming Delaware or services LLC. And that's it. That's the only thing of record with Delaware. And so they don't know about family trust. They don't know about the settlers being the managers. That's all covered by the operating agreement, which is not public record. Any questions?
Okay, so going back to clarify what we talked about a few minutes ago, if we don't have this set up right now, we can still set it up and change where our entities are, or how to get that set up the right way, correct?
Yeah, so, the way I've done that in the past, where people have been out practicing and doing real estate, is I always just tell them what's done is done, right? So I'm not going to be moving current real estate into, the Delaware LLC entities or anything like that, because now you're kind of ruining what we're creating here. So what you do is you create the structure for anything going forward, for all future property acquisitions, all future contracts, all future rental properties, those types of things. What's done is done. You just keep that other stuff separate and you deal with it. You don't start moving it, because then you can see, oh, the warranty deed from, Sean St. Clair into this Delaware, LLC. Well, okay, this was done outside of title insurance, done by Sean, it's pretty good indication that Sean owns the Delaware LLC, right? And he's just moving for asset protection purposes. So you don't want to start, tainting the new structure. And so you just start anew, and going forward, the way you operate is with the new structure, and you just keep what's done is done over here, and just let it be and let it go, and operate it as it currently stands. And then you start anew with a different structure, if you will.
Yeah. No, I watch a lot of Pace's stuff, and he constantly is talking about those structures that way and setting stuff up. So it's really good. So, and I think we had another question, but I think, Steve, it got answered about the LLC earlier, that because we're, let me find it. Do an annual reports apply to LLCs with S Corp election in Arizona? And it doesn't, because we're not a corporation. They're the LLC.
Yeah. So, and this is very important to understand, because don't make the mistake of forming a corporation because we use the term S Corp. When we use the term S Corp, we're referring to a tax designation and not an entity choice or entity structure. It's simply a tax designation, and an LLC can elect and be taxed as an S Corp. It does not have to be formed as a corporation. So that's a great question, and something that, everybody on here, write down, take note of. Don't run out and file a corporate or form a corporation because you want an S Corp, because you're actually hurting yourself with annual report filings. Now you got to do bylaws. You can't do an operating agreement. There's a lot of different things that, you don't want to have to deal with simply because you choose a corporation over an LLC.
Well, and with that being said, Sean, I mean, are you accepting new clients? Are you available for the people?
Yes.
Or
Yeah.
people? And is it just something that they get a hold of you, set up a meeting or something, and go from there? Or how is it your contact?
Yeah, great question. So the way I operate is I'm happy to schedule a consultation. Anything that's scheduled with me is, a paid consultation. Or if you retain, my office, then, we can schedule a meeting, that type of thing. But I'm always happy to, have a 10, 15, 20-minute conversation with somebody. If you call and I'm able to pick up, I'll pick up. Otherwise, I return my calls, generally within 24 hours in the afternoon. Happy to have that conversation with you and say, what are you looking to do? I can give you kind of a rough, quote on what it's going to cost in that, phone call. And then, we can get an engagement letter going and the file set up, and then I can meet and go through everything, the structuring with you. But if, you want to meet and say, hey, Sean, show me the structure that you think we should create. And I, am doing that type of planning. I do charge just a
Okay,
consultation.
no, that's
fee.
fair. And
Yeah.
what's the best way for people to reach you? Phone number or email?
Phone is the best. Yeah. And that's 480-359-7206.
7206. I'll put that in the chat, you guys, and I
Perfect.
will make sure
I
it's on
have-
the Facebook page, but you have a question. Who just had that? What was the Facebook group?
Yeah, I have two quick questions if possible. That's one of them.
Okay. It's real estate investor legal.
Okay,
Real estate investor.
legal.
Okay.
And one more question, Sean, from me. If someone was interested in purchasing like a commercial property, like a bar, would you be a lawyer for that for type of business as well too?
Absolutely. Yeah, I do a number of commercial transactions where I represent the buyer and, work with them on their due diligence, contract review, title review, survey review, those types of things. So
Okay, perfect.
I'd be happy to do
Thank
that.
you.
Anybody else got some questions out there?
What was the number again?
Yeah, 480-359-7206.
And I just put it
Thank you,
in
Sean.
the
You.
group there. Okay, so one other thing, Sean, that I have to, Marie reminded me to share with you is, one, we do put you down as our preferred legal advisor in the stuff that we do, that we advertise on our, like this group, this weekly
Yeah.
huddle and stuff that, just here, if you need legal advice for real estate, this is who we would recommend. So the second thing with that is Marie and I have written a book and we put you in there as our, so you need.
Oh, wow.
It's
Oh,
a,
that's cool.
it's a how to save money on capital gains. So we're sending it over, but we were like, if you need, the whole time, every other line in there is talk to your legal professional, talk to your tax advisor.
Yeah, exactly.
But it's just a 30,000 overview of, some capital gains. We've been working with a CPA, but anyway, she wanted me to mention that to you.
Is that book like on Amazon or? where
It's
would I
gonna
get a
be,
copy
we're
of that?
still
Okay.
finalizing it. It'll be on Amazon. It'll be something that'll be on our website. We're gonna hand it out. So, yes.
Yeah, you'll have to keep me in the loop on that because I definitely would like to read it.
Oh, yeah, no, for sure. I'll talk to her now and see if I'm sure we can get the copy over to you.
Okay.
It's some late night, I can't sleep reading,
Oh,
but it gets you there. But I wanted to let you know that. So
awesome.
we really, in fact, with that, I'm going to stop probably